G'day everybody and welcome to topic 2 of Laws 11061 Contracts A. My name's Anthony Marinac and this week we're going to start looking at what we call the elements of contract formation. So why are these important? Well, the elements of contract formation tell us whether or not there actually is a contract. You see, there are all sorts of promises in life. Some promises are important, some promises are minor and insignificant and just made along the way, and not all of those promises are contracts. What's the difference between a contract and any other sort of promise? Well, the key difference is that a contract is a type of promise that will be enforced by the law. A contract is a type of promise that you can go along to the court with and say, Your Honour, I've got a contract with this person, they've made me a promise and they haven't delivered on it, so I would like the court to now get involved and force this person to deliver upon the promise that they have made me. So it's important to be able to tell what sort of promises or what sort of obligations are under a contract and which are not. And the way we do that is by looking to the elements of contract formation. So these elements of contract formation all go to asking the question, is there a contract? Now, if there's not a contract, then the rest of what you learn in contract law really has no application at all. It doesn't matter how you read the promise. It doesn't matter whether the promise has been delivered on. It doesn't matter what sort of remedies the person might want to be after. None of that matters at all if you don't have a contract to begin with. So the first thing that we do in our study of contracts is look at the elements which will tell us whether there is a contract at all. And those elements, there are 5 of them. We'll look at them over the coming weeks. The first element that we look at is capacity. Capacity means, is the person or are the parties, both the parties who have been party to the contract, are they actually able to take part in a contract at all? Let's break that down a little bit. What we're actually going to be looking at is first some of the factors affecting capacity to contract. The 3 most obvious ones of those are age, mental capacity, and intoxication. Then we're going to look at what actually happens if a person who lacks capacity does purport to enter into a contract, because whilst it might be pretty tempting to say, well, they just can't enter into a contract, the reality is that oftentimes they actually do. So the law needs to work out how to deal with things in a way that echoes of justice, even when a person who doesn't have capacity has just gone ahead and entered into a contract anyway. Once we answer those questions, that leads us into the ability to distinguish between a whole bunch of different types of contracts. Binding contracts, where both parties have capacity, and then contracts which require either repudiation or what we call ratification, and then avoidable contracts and void contracts. Most of which will make no sense to you at all right now, but let's see how we go by the end of the lecture. Let's start with the simple stuff. Who is a minor? Now, a minor in contract law is a person who is less than 18 years of age. And that comes to us in Queensland from Section 17 of the rather humbly titled Law Reform Act 1995, which says that a person is a minor until they turn 18. In practicality, what that means is that from essentially midnight on the commencement of the person's 18th birthday, they are regarded as having reached the age of majority. Now, this is quite interesting in a lot of ways, because whilst the law regards a person as having received or having reached majority at that point, there are a bunch of other age checkpoints along the way at which people's legal capacity and legal rights change. So, for instance, upon reaching the age of 16, a person becomes entitled to engage in sexual relationships. At the same age of 16, a person becomes entitled to marry with parental consent. At the age of 17, a person becomes of legal capacity in terms of criminal law. So a person is liable to be held criminally responsible from the age of 17. If you look at the world of commerce, which is, I guess, the world that we look at somewhat more rather than less in terms of contract law, you find that quite often commercial entities will require children as young as 14 and 15 to pay the same price as an adult in circumstances where there's an adult's price and a children's price. I think the last time I booked airline travel for children, the adult price applied to a child over the age of about 11. So you can see that whilst we talk about minors being persons who are less than 18 years of age, in reality, within society, we have a whole bunch of different age markers, and so it becomes quite confusing. And it can also seem, particularly to young people, it can seem quite unjust that the age of majority is 18 years of age. For instance, if we did talk about those airline tickets, we say to a young person, well, because you're older than the age of 11, you have to pay for an adult's fare, an adult's seat. But by the way, you can't do that yourself. Even if you should have the money, you can't do that yourself because you haven't reached the age at which you can make a contract. Now you can see how there's a sort of an inherent unfairness in that idea that you can be old enough to be an adult in certain contexts when it suits other people, but not old enough to be an adult in certain contexts when it suits you. Having said that, the bottom line is that for contract law, the magical age is 18. The magical day is the 18th birthday. So, what does that mean in terms of minors? Does it mean that minors are completely unable to enter into contracts? The answer to that, pretty clearly you'll see from your own personal experience of life, is no. Because we've already said that contracts are everywhere and that contracts can be anything from a massively important contract like getting a job or buying a house, right down to relatively insignificant contracts like buying a can of Coke or a stick of bubblegum. What that means is that as far as the law is concerned, every student who goes along to their primary school tuck shop and buys an ice block is engaging in a contract. And so it would be very difficult and probably counterproductive to the development of responsibility in young people if we said that minors were never able to enter contracts at all, that the entire body of commerce was unavailable to a minor. So the law doesn't say that. Instead, what the law does is put a bunch of rules around how contracts work between minors and adults. We're going to go through some of those rules. But before we do, we have to start by understanding the difference between what we call a void and avoidable contract. You see, as we go through and look at the rules for how minors engage in contracts, we're going to divide all of the contract types up into three. There's going to be binding contracts, void contracts, and voidable contracts. Now, a binding contract is pretty obvious. A binding contract is one which is binding on both parties. Either side could potentially go to the judge and say, hey, I'm being done over here. I want the court to step in and do something about it. That's pretty simple. I don't think that gives anyone any difficulty. A contract which is a void contract is one which cannot be enforced at all. So it doesn't give any legal rights before the court. The court will simply not take any steps in relation to that contract. Now, there are all types of void contracts, and Later on in our study of contracts, we'll find out that some contracts are void for public policy reasons. So, for instance, if you bribed a politician to vote a particular way on a particular bill, that would be a void contract because public policy says that it's not okay to, you couldn't turn around and say, but I paid him my $10,000 and he didn't go and vote the way that I said. The law's not going to take any recognizance of that because public policy says it's not a good way to go. So you can see a void contract is one which the court just won't look at all. Those two are pretty simple. I don't think it's too hard to understand the difference between a binding contract, which is binding on both parties, and a void contract, which is binding on nobody. The difficult one is a avoidable contract. Now, a avoidable contract presumes that there are two parties, a strong position party and a vulnerable party. In this case, obviously looking at minors, we're talking about an adult contracting with a minor. Now, a voidable contract can only be enforced by the vulnerable party. So let's say I made a contract with a minor and it was a voidable contract, and you'll find out as we talk about the next few slides whether contracts with minors are void or voidable. Let's say I made a contract with a minor to mow my lawn, and the contract was recognised as being voidable. What that means is that if I'm unhappy with the way the minor mows my lawn, I can't enforce the contract. I can't really do anything about it because I'm the party in a position of strength. The minor, on the other hand, if they should mow my lawn and I should fail to pay them, they could choose to enforce the contract. So in other words, the party who's in the vulnerable position gets to decide whether the contract is going to be enforceable or not. So the contract is not void, it's voidable. They can make it void. Okay, the vulnerable party can decide that the contract is going to be void. Now, having made that distinction between those three types, let's go through and have a look at some of the cases, and let's look at how contracts with minors actually work. The first thing we look at is contracts for necessaries. Now, a minor may make contracts for what we call necessary items. Now, the problem with necessary items as a concept is that there's not actually that much in this world that is truly necessary. I mean, once you've got food, water, basic shelter to keep the weather off you, and some sort of basic clothing to meet minimal social standards of modesty, anything beyond that is not really necessary. What the court has said is that in the context of minors making contract law, necessaries are those things which are appropriate for a person in that minor's station in life. And there's a great case that illustrates this concept called Peters and Fleming, and I've referred to that in the notes. It's an 1840 case. In this case, Fleming was a young man whose dad was a member of Parliament. Fleming was at Cambridge University as an undergraduate, and at this point in time, the age of majority in England was 21 years of age. And look, I don't recall from the case, but I think Fleming was around 19 or 20 years of age at the time. And he went to a jeweller near Cambridge University, and he made a number of purchases, some rings, a watch chain, and a pair of pins. And we're talking about here, heavy brass or gold cloak pins. And He then failed to pay, and so the jeweller sued. What happened was that the judge at first instance decided to put to a jury, because they used juries much more extensively in those days, put to a jury the question of whether these items were in fact necessaries, whether they were necessary for the position of a young man who was a university student at Cambridge. And the jury came back and said yes, they were. And so there was an appeal to the Court of Appeal, which said, well, some of these items at least, for instance the pins, they are potentially useful. They're not merely ornamental in nature. I mean, if this young fellow is at Cambridge and he's wearing a cloak, he may well need cloak pins in order to keep his cloak from falling off him, and that seems reasonably necessary. It seems like the sort of thing that a young undergraduate student at Cambridge ought to have. And so the Court of Appeal had no problem with that question having been put to the jury. They were much less certain about the rings and the watch chain. Sorry, about the rings. The watch chain they were perfectly happy with, because of the idea that the watch chain could be used to hold a watch, and that having a watch is a normal thing for an undergraduate student. Much less certain about the rings, because they were really just ornamental. Now, if the miner had been buying, for instance, a wedding ring because he intended to marry, that might have been kind of different, because a wedding ring serves more than just an ornamental purpose. But what the court said was that because at least some of the items were necessary and useful to the miner, it was pretty reasonable for the court to put the question to the jury as to whether the jury considered them to be necessary. In a modern context, we might say that there's a number of things that miners ought to be able to contract for as being necessary. A great example might be here in Brisbane, on the public transport system, they have what's called a Go card, which is like a prepaid electronic proximity card, which allows you to use the public transport system in Queensland. Now, many miners, of course, do not have driver's licences, and so they're heavily reliant on public transport. And the Go card is obviously a contractual situation where you pay money to the company TransLink up front, and in return for that, TransLink takes on the obligation of providing you with transportation up to the value that you've paid for. So it's pretty reasonable to think that most miners, in order to be able to get around, in order to be able to get to their work or their study, or in order to just basically live a normal life, miners are going to need to be able to contract with transport providers in order to have their basic mobility. So a contract like that would be a contract for something that's necessary. What happens if you've got a contract for a necessity? Well, a contract for a necessity is binding. Okay, so a contract for a necessity is immediately binding upon both parties. Second question we have to ask in relation to necessaries is whether the miner already has a sufficient supply. And for this, we look to a case called Nash and Inman. Yet another case about Cambridge undergraduates. This guy went to a Savile Row tailor. At least he's got good taste, and he ordered a whole bunch of waistcoats. Now the problem is that his father had already provided him with an adequate supply of waistcoats. So if you've already got 8 waistcoats at home and you go along to a tailor and order another 5, can you really say that those extra 5 are necessary? Even if waistcoats themselves were necessary in those circumstances, could you really say that the extra ones are necessary if you've already got an adequate supply? Well, the court said no. The court said that in this case the contract was not binding on the miner because it was not a contract for a necessary, because the miner already had an adequate supply. Now, personally, I think that's really dodgy, because it's very difficult for the tailor to know whether or not the miner already has an adequate supply. The most that they could possibly do is say, look, do you have an adequate supply of waistcoats? In which case they'd still have to take it essentially on faith from the miner that the miner was telling them the truth. So personally, I think this is a bit harsh, but the rule is that the miner must not already have a sufficient supply. If the miner has a sufficient supply, the contract becomes voidable. So what that means is that if the miner already has a sufficient supply, they can still go buy more waistcoats, but the merchant is at a position of risk, because the miner can enforce the contract, but the merchant cannot. The other sort of contract for which miners can enter into a binding contract, so they can enter into a binding contract for a necessary where they don't already have a sufficient supply. They can also enter into contracts for what are called beneficial contracts of education or employment, because it's recognised that most miners, at least towards the end of their period of minority, are going to be engaging in either educational activities such as university or an apprenticeship, or they're going to be taking their first steps into the world of work. Now, it would be very harsh on a miner to be unable to get work because they are unable to sign an employment contract, and the law recognises this. So what the law says is that if a miner is engaging in a beneficial contract of education or employment, and if that contract is genuinely beneficial to the miner, then it is binding. If not, it's just voidable. So how do we actually make this work in terms of our legal reasoning process? Because as I sit here and lecture this material to you, it seems to me that it's quite complicated. How do you work your way through this forest of void, voidable, and binding? Pretty simple. The first thing you do is establish whether there's a miner. If there's a miner, then you think, right, we now need to start worrying about these rules of minority. The starting position, as soon as you identify a miner, the starting position for you is the contract is probably voidable. We know it's not going to be void because we know that miners can make contracts because they can go and buy a can of Coke or an ice cream at the tuck shop. So we know that a contract with a miner is not void. The starting position is going to be it's voidable. It can be enforced by the miner, but not by the other party. So we start out by saying the contract is probably voidable unless the contract is either for a necessary or it's for a contract of beneficial employment or education. If you can make it fit into one of those two categories, then it becomes binding. Okay, so it becomes a lot simpler to handle then. Is there a miner? Yes. Well, since there's a miner, the contract is going to be regarded as voidable unless we can find something to make the contract binding, which means the contract would have to be for something necessary or it would have to be for a beneficial contract of employment or education. There's only one final thing we need to talk about with miners, and that is that the law relating to contracts with miners has been modified in a slight way by what we call the Sale of Goods Act 1896 in Queensland, Section 5, which says in very old language, when necessaries are sold and delivered to an infant, the person must pay a reasonable price therefor. When they speak of an infant in that sort of old legislative language, they mean a minor, so anyone aged less than 18. What the effect of that provision is that you can't overcharge a minor. Okay, so that a merchant cannot take advantage of the vulnerability of a minor to charge them a price which they would not charge to any other customer. We then need to go on and talk about what's called we then need to go on and talk about mental disability and intoxication. Now, the reason we can deal with this stuff pretty quickly is that it works almost the same as being a minor. You see, as a minor, you lack the full capacity to enter into contracts. You can only enter into binding contracts for necessities and for beneficial contracts of service. And what the law says is that if you have a mental disability or if you're intoxicated, then you also lack the capacity to enter into binding contracts. Let's start by breaking down what we actually mean by mental disability. If somebody is permanently mentally disabled, either as a result of some sort of psychological or psychiatric condition, or as a result of something like a brain injury, or as a result of some sort of congenital issue, which means that they lack the full intellectual capability of most people, they're quite often going to have a guardian or an attorney, someone holding a power of attorney, and that person will be engaged in contracts on their behalf. Now, under those circumstances, we don't really need to worry about these rules of capacity, because the person with a mental disability themselves is not going to be engaging in the contracts. What's going to happen is that somebody else who has full capacity will be contracting on their behalf. What we're talking more about here is situations where someone with a mental disability does make contracts on their own behalf, or alternatively, situations where somebody may have a temporary mental disability. So an example of that might be somebody who has a concussion. Okay, so they're temporarily in an altered state of mind, but they're not going to be for long. They're going to be returned in the ordinary course of events to full capacity. If you think about it, intoxication is really the same thing. I mean, somebody who is intoxicated is in an altered state of mind. Intoxication is, in effect, the same as having a minor and temporary mental disability. You're not processing information the same as you would if you were sober. At least I'm certainly not after a couple of glasses of bourbon. You're not making decisions in the same way that you normally would. You're not assessing risks in the same way that you normally would. So being drunk or being intoxicated by drugs really is the same as having a minor mental disability. And it's probably important to say there that we are talking about both types of intoxication. We're talking about intoxication as a result of the consumption of alcohol and intoxication as a result of the consumption of drugs, be they illicit drugs or any of the many types of prescription drugs, which will leave a person with a reduced capacity to think and look after their own interests. If a person who is under a mental disability or who is intoxicated makes a contract, the law will ask two questions. First, the law will ask, was the person capable of understanding the nature of the contract? If they are not capable of understanding the nature of the contract, then the contract will be voidable. So they will be able to pull out of the contract at any time. What do we mean by understanding the nature of the contract? Well, if somebody doesn't really even understand what they're contracting for, then it's pretty harsh to turn around and say that they should be bound to that contract. Doesn't mean, however, that they need to understand each and every provision of the contract. What it means is that they have to have at least sort of a sufficient understanding of what the contract is intended to do in order for it to be binding. How does the court work this out? Well, it works it out on a case-by-case basis depending on the facts. So if you're the one trying to insist that the contract is binding because the person did understand the nature of the contract, then you need to be able to bring facts forward to show that. The second question the court will ask is, was the other party aware of the condition of the impaired person? So if you make a contract with someone who has a mental disability, but you have no idea that they have a mental disability, or if you make a contract with a person who is intoxicated, but you have no idea that they are intoxicated, well, it's a bit harsh for the law to say, well, you can't enforce that contract, even though you thought you were dealing with someone who had full capacity to make a contract. We can't really expect people who are making contracts to take steps every time they make a contract with someone to confirm that the person's not under a mental disability and not intoxicated. So what the law says is that if the other party is aware that the person is mentally disabled or intoxicated, then the contract cannot be enforced by that person. So if you knowingly make a contract with someone who has a mental disability, or if you knowingly make a contract with someone who is so intoxicated that they're unable to understand the nature of the contract, well, basically you have to suck it up, because you're not going to be able to enforce that contract. On the other hand, if you don't know, and let's face it, somebody might have a condition like schizophrenia, and they might come across as being entirely rational and often very intelligent, and yet they might still be in an altered state of mind which makes it unreasonable to hold them to a contract. If you're not aware of their condition, then the contract may still be enforceable. All of this brings us to the last consideration, which is two concepts that we call ratification and repudiation. When we think about the three types of lack of capacity we've discussed, we've discussed minority, mental disability, and intoxication. Now, in the context that we've been discussing them, all three of those things are temporary. Minority is temporary because in the normal course of events everyone will turn 18. Mental disability in this context is temporary because if it was permanent disability we would be looking at a situation where somebody had a power of attorney. And intoxication is temporary because, well, pretty much everyone sobers up eventually. Question is, what happens then? If a person makes a contract at a time when they lack capacity, but then later on they obtain capacity, what happens to the contract? Well, essentially the person who has obtained capacity has two options. They can either ratify the contract or they can repudiate the contract. The person ratifies the contract by either stating, right, I now have capacity and I consider myself to be bound by this contract, or alternatively, they can ratify the contract by continuing to act as though the contract is binding upon them. So let's say you're 17, you make a contract where you sign up for access to a website. Let's say you're a 17-year-old who's very keen on the news and you've signed up to get past the Fairfax paywall, and you've signed up for 12 months, and 3 months later you turn 18, and after you've turned 18 you continue to access the website and you continue to make a couple of payments. Well, essentially you've ratified the contract because you've continued to act as though the contract was binding upon you. The other option that someone has once they reach that position of capacity is to repudiate the contract. That is, they can turn around and say, I no longer consider myself to be bound by this contract. I don't want to participate anymore. Now, this can only happen in the case of a voidable contract. But remember, most of the contracts that we've been talking about are voidable. The starting position is that they're voidable. So you can get to the age of 18 and say, let's say again, the young person is signed up for the Australian. They get to their 18th birthday and they say, you know what, I'm not really into this news stuff. I think that I made a bad decision by signing up for 12 months. I probably made that decision because I was a bit too young and immature. I wish to repudiate the contract. Well, the law will be on their side. As long as they repudiate the contract by words or acts very soon after they reach the point of capacity, they'll be able to essentially get off scot-free. So what have we learned in this topic? First, we've learned that minors, who are people under the age of 18, have a limited capacity to enter into contracts. They have a limited capacity to enter into contracts because the contracts that they enter into are generally not binding on all parties in the way that a normal contract is. They are generally voidable by the minor. We've learned, however, that contracts for necessities or necessaries are binding on the minor, so they're binding on all parties. Things are necessaries if they're appropriate to the minor's station in life and if they don't already have an adequate supply. Furthermore, a beneficial contract of employment or education is also regarded essentially as a necessary, so it's binding on all parties. In any other situation, a contract with a minor is voidable. It's voidable by the minor. So if you have a contract with a minor, ask yourself, is it for something necessary? Is it for something appropriate to their station in life? Do they have an adequate supply? Is it a beneficial contract of employment or education? Because if it's not one of those things, it's voidable. Second, we've learned that contracts with people who are intoxicated or mentally unwell, those contracts are voidable. They're voidable if the defendant was unable to understand the nature of the contract and if the other person knew knew of their condition. If one of those conditions doesn't pertain, then the contract is going to be void. Finally, we've talked about the fact that voidable contracts can be ratified or repudiated. They're ratified if the party who's reached capacity turns around and continues to act as though the contract was binding upon them. They're repudiated if the party, through either words or actions, makes it clear that they no longer intend to be bound. So that's the first steps in our study of contract formation. Next week we're going to look at the intention to create legal relations, and through the following 3 weeks we'll go on and look at all of the other elements of contract formation. Hope you have a great week. Talk to you again soon.